Can a LinkedIn connection request lead to a finding of poor moral character? Apparently, yes. At least in one reported USCIS case. USCIS reportedly cited an applicant's LinkedIn connection requests to agency officials as part of the basis for denying his naturalization application. No threat, no hostile message, no actual outreach, just a request to connect so the officials could view his profile. USCIS reportedly wrote that this reflected poor judgment and cast doubt on his good moral character. That is not even the most significant change this week. It is simply the one that caught the most attention. Welcome back to US Visa News Hub. I am Mr. Burhan. There are several quiet updates in how USCIS is adjudicating cases right now. Changes with no press conference, no big headline. Changes you typically only hear about through individual cases until they become more widely known. I want to walk you through a few of the most important ones so you can stay ahead of them. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. Here is why these smaller changes matter more than they used to. In the past, small or procedural errors often had room to be corrected. That margin appears to be shrinking. Small mistakes can now lead to denials, refusals, or findings of non-compliance that follow a case going forward. Change number 1. The new alien registration rule. USCIS finalized this rule on June 29, 2026, and it barely made headlines. Here's the core idea. If you are a non-citizen age 14 or older and in the US for more than 30 days, you are required to be registered with fingerprints unless exempt. If you move, you must report your new address within 10 days using Form AR-11. This has long been the law, but failing to file now carries real civil and even criminal exposure, including fines and potential jail time. Most people watching this who entered on a visa, have a green card, an I-94 or a work permit are already registered. You generally do not need a new registration, but the 10-day address change rule is where people slip up. If you move and forget to update your AR-11, you're technically out of compliance, and enforcement of that used to be lax. That no longer appears to be a safe assumption. If you move, file your AR-11. It takes a few minutes online through your USCIS account. It's also worth knowing that AR-11 itself may soon expand to ask about employment history, education, and financial self-sufficiency, aimed at evaluating public charge concerns. That proposal has been open for public comment through early July 2026. Change number 2. The shifting status of TPS. This is moving fast, so here's a simplified roadmap as of this week. Some countries still have active, unterminated TPS designations, including El Salvador, Sudan, Ukraine, and Lebanon. A second group has had TPS terminated by DHS, but the terminations remain tied up in ongoing litigation, meaning protections are currently still in effect for now. This includes Ethiopia, Somalia, South Sudan, and Burma/Myanmar, along with Honduras, Nepal, and Nicaragua, where the legal status has shifted back and forth in federal court. The third and most serious group includes countries where termination has already taken full legal effect: Afghanistan, Cameroon, Venezuela, and Yemen. And most recently, the Supreme Court ruled on June 25, 2026, that DHS can proceed with ending TPS for Haiti and Syria. But that termination is expected to take effect around July 27, 2026, not immediately. So if you're a TPS holder from either country, your status and work authorization are still valid for the moment. If your country is affected, check the official USCIS TPS page directly, since these statuses continue to shift. Change number 3 brings us back to the LinkedIn case and the broader shift in how USCIS applies the good moral character standard for naturalization. This has always been a requirement, but under a 2025 policy memo, USCIS now applies a more holistic, subjective standard, looking beyond the absence of wrongdoing to a person's overall pattern of behavior. Section 101F of the INA lists specific disqualifying conduct, but it also includes a catch-all provision that lets an officer find someone lacks good moral character for reasons not specifically listed, as long as there's a sufficient basis in the record. That catch-all appears to be where this shift is happening. In the LinkedIn case, USCIS reportedly used exactly this provision, reasoning that reaching out to agency officials on a personal platform crossed a professional boundary. That decision is currently being challenged. The practical takeaway. USCIS already monitors social media activity broadly, so be mindful of what you post, like, or share while your case is pending, and never contact USCIS officers directly outside of official channels. The last point is more subtle, but arguably the most consequential, because it affects people who have done everything right. It concerns how USCIS is now handling extensions and changes of status. Historically, if you filed an extension before your status expired and later filed to change to a different status while that extension was still pending, that pending filing generally bridged your lawful status while USCIS processed everything, a strategy attorneys have relied on for years. That does not appear to be working as reliably anymore. Immigration attorneys have reported recent denials involving families in this exact situation. For example, a family on H-1B and H-4 status whose status was set to expire, with the H-1B extension filed on time before that deadline. Months later, while that extension was still pending, the family filed to change to F-1 student status. USCIS denied the change of status, stating the family had been out of status since the original expiration date, even though the timely filed extension was still undecided in USCIS's own queue. If that extension is later approved, it would technically relate back and mean the family was never out of status at all. Importantly, being out of status is not the same as accruing unlawful presence. Those are separate clocks, and a timely filed, still pending extension generally means no unlawful presence has accrued, which matters for the 3-year and 10-year re-entry bars. Options in this kind of situation can include a motion to reopen, a motion to reconsider, an AAO appeal, or in some cases litigation, though success rates on motions and appeals are reportedly inconsistent. If you're relying on a bridging strategy right now, it's worth talking to an attorney about a backup plan, and premium processing may help avoid this timing problem altogether in qualifying cases. It's been a busy stretch in immigration, from the birthright citizenship ruling to these TPS and registration changes, and it's a lot to track. If any of this affects your situation, drop your questions in the comments and subscribe to US Visa News Hub so you don't miss the next update. Thank you for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.